please. Hello, good evening. Welcome to our talk this evening on the HKIAC Administered Arbitration Rules for present and a look to the future. We have also patched in our Philippines chapter so that they can participate in the Q&A later. Welcome, Philippines. Anyway, to start off,
thank you.
I think most of you already know our two speakers, but let me just very briefly introduce them. We have Chiann. In fact, I met Chiann on the first day at the HKIAC. How many years ago was that?
Yeah, a long time.
Long time ago.
7 years ago, yeah.
So Chiann, as you know, used to be the Secretary General of HKIAC. She was very instrumental in a lot of things that happened here, including the revision of the HKIAC Administered Arbitration Rules, the establishment of the Tribunal Secretary Accreditation Program, as well as the opening of the Seoul and Shanghai office of the HKIAC. I've actually been to the Seoul office, very nice, and nice person working in there. Chiann is a lawyer by background. She used to work in a law firm in New York before she joined HKIAC in 2010. That's the year we meet. She is a JD of University of Wisconsin Law School, got her MA from City University, and had her undergraduate studies from Cornell University. She's admitted to the bar in New York, and she's been featured in a number of directories now, Asian Legal Business 40 under 40 list, named as one of the most highly regarded individuals by Who's Who Legal and Asia Legal Arbitration 2017, and comment one of the superstars of Asian arbitration. We also have Joe Liu. Joe has also been educated in the U.S. With a master's from New York University, also a master's from LSE, and an undergraduate from Wuhan University. He's also admitted to the bar of New York. He's the current managing counsel of HKIAC, and he supervises and administers arbitrations and other disputes in Hong Kong, whether it be in English or Chinese. So he's acted as secretary in plenty of tribunals, and is a member of the HKIAC Rules Revision Committee that drafted the 2013 HKIAC Administered Rules. So both of them certainly were very much involved in the 2013 arbitration rules, and it's opportune that they should be now speaking on what you can hope to see in the future. Thank you.
Great. Thank you very much, Mary. It's always nice to be back here. This is one of the few times I've actually had the opportunity to speak at HKIAC since I left about a year ago, and the first time was, in fact, the launch of this book. And so when I was asked to do this presentation, I think Nicholas said, oh, I think you've done many of these presentations introducing the book, but in fact, this is the first one we're doing. And so you'll have to pardon me for any rough edges in this presentation, but certainly it is a pleasure to be here again, and we wanted to spend the next hour with you, sharing with you some of the key highlights of the book, and also give you a glimpse as to the thinking behind the most recent, the consultation paper that was made public a couple of weeks ago now.
29th August.
The 29th of August, in anticipation of a revised set of rules. So many of you will have seen this book now, and actually this book is part of a series that OUP has done on institutional arbitration rules. And probably 6 years ago or so, after the launch of, actually maybe less than that, about 4 years ago, before the establishment of the 2013 rules, Michael asked me, oh, wouldn't it be fun to do a book on the institutional rules? And Michael has clearly done many of these books before. I had never done one before, and so I didn't really know what I was getting myself into. But certainly through all of the contributions of several people in the community and in the instrumental support of Joe, this book came to fruition earlier this year. What we want to focus on today, of course, is not so much the book itself, but rather the substance of the book. The book is anticipated to be not just a description or a regurgitation of the institutional rules, but rather, and provision by provision, but rather it's supposed to be more practical. And we drew inspiration from the ICC Secretariat's guide, which to those who have used that guide, I found to be hugely invaluable in learning the insight as to what the institution does and how the institution interprets certain provisions. And so we really wanted to take that angle, certainly because I was the author as well as Michael, who is obviously chairman of HKIAC. We wanted to take that angle and really give the users the Secretariat's view. And hopefully we have achieved that. The key features of this book is intended to be really a one-stop shop, similar to the HKIAC, in anything that you need to know about HKIAC arbitration, but also arbitration in Hong Kong. And so some of the key features of this book, in fact, are, an overview as to HKIAC arbitration in Hong Kong. There is actually also a cheat sheet in the appendix on the advantages of Hong Kong and HKIAC. And that is intended for those of you who work at law firms and are oftentimes asked by your corporate lawyers as to what the differences are between Hong Kong and Singapore or other seats. This is intended to be a useful cheat sheet for you in explaining the various advantages or attributes of arbitration in Hong Kong and HKIAC. Another feature is the various flowcharts that exist in this book. And so in addition to the advantages in the cheat sheets, you also have different flowcharts as to, for example, the expedited procedures, emergency arbitrator rules, as well as the HKIAC commencing an arbitration in general. So you'll see various of these flowcharts in here, which are intended to really, simplify your life when explaining what the arbitral process might be for your clients. Another feature is really an insight into HKIAC Secretariat. Obviously, many of the references to the decision maker is HKIAC, but what is HKIAC? And HKIAC, many institutions have, for example, courts that make decisions on appointing arbitrators, on dealing with challenges, dealing with different interpretation of the rules. HKIAC does not have in its DNA the concept of a court. And so a few years ago, what was established was two different sets of committees, the Proceedings Committee and the Appointments Committee. The Proceedings Committee functions primarily as the body that makes decisions on consolidation, joinder, some of the more substantive aspects of interpreting the arbitration rules, threshold issues as to jurisdiction are all decided by the Proceedings Committee. The Appointments Committee is, as the name suggests, deals with the appointment of the arbitrators, deals with fees associated with the arbitrators, etc. And the way that it works between the Secretariat and these committees is basically the Secretariat will do all of the hard work in preparing the agendas on a almost daily basis. I mean, the way that it works at HKIAC is that there is not a weekly meeting with these committees, but rather this is all done over email, and the decisions are made via email with the committee members, which allows for a more efficient process. So the decisions as to the appointment of arbitrators, jurisdictional issues can be decided within a day even. Joe maybe be able to comment a little bit more on what the Secretariat does, to the extent that it's changed since I've been here, in preparing the agendas. I don't know if you have any thoughts on that. I should introduce Joe. Joe and I are partners in crime on this one, and he's really going to do some of the heavy lifting today, but maybe you can
I think
give some
the
insight.
practice pretty much remains the same. So we prepare AC and PC agendas, which includes summaries of the case, and including the Secretariat's recommendation. So if it's an appointment matter, say where HKIAC is to appoint an arbitrator, then the Secretariat will usually draw 3 names, and including 1 female to the extent that we can, and then put the proposal forward to the AC, and for the AC to decide. As Chiann said, that everything is done by email, so the process is very efficient.
Oftentimes the comments, so I'm on the appointments committee, and oftentimes the comments that will be made among the committee members may be, you know, when was the last time we appointed this person, or, you know, whether their fees are too high, or whether the individual is really appropriate based on the criteria set by the parties, and those are the kind of comments that are made in the appointments committee. What kind of conversations, what are the more recent proceedings committee decisions that have been made? I know there's one on
consolidation, and the proceedings committee deals with pretty much all procedure matters that the AC doesn't deal with. So for example, challenges to arbitrators, consolidation of multiple arbitrations, joint arbitration of parties before the tribunal is constituted. So a wide range of different matters, but I can talk about it when I get to the different stages of the arbitration.
Right. So that is kind of the infrastructure as to HKIAC's decision-making process. All of these decisions are final pursuant to 3.1 of the HKIAC rules. There have been a couple of decisions that have been made that have been reversed, and this has actually prompted proposed revision of 3.1 to the extent that any HKIAC decisions are made, there may be an opportunity to revisit those decisions. And that's it on this slide.
I think one question the audience might have is how to get a book.
Oh, right. I know Amazon sells it.
Or you can go to OUP's website.
OUP's website? I don't actually know. I have a whole box in my office. You can come to me. Yeah.
Okay. So thanks, Chiann. Thanks, Mary. It's great to be here at my home base to talk about the HKIAC rules and share our experience and any future changes. So I will just get right into it. So when you decide to refer the dispute to HKIAC arbitration, the first step is how do you commence an arbitration under the 2013 HKIAC rules. So under the rules, an arbitration is commenced when the claimant submits a copy of the notice of arbitration to the HKIAC. And the day when we receive the notice of arbitration is the day when the arbitration is commenced. Now, when the Secretariat receives the notice of arbitration, there are a few things to do. One is to review the notice of arbitration against the requirements under Article 4.3 to see whether or not the notice of arbitration is complete or not. Article 4.3 includes a number of components to be included in the notice of arbitration. For example, the contact details of the parties, a reference to the underlying contract, a copy of the arbitration agreement, proposal a proposal on the number of arbitrators if the contract doesn't specify the number, or designation of an arbitrator. So we will check through that, and if the notice of arbitration is missing anything, then we'll go back to the party, go back to the claimant to ask the claimant to supply the missing information. The claimant is also required to pay 8,000 Hong Kong dollars as the registration fee. So that is something that the Secretary will also check as well. So if the notice of arbitration is incomplete, then under Article 4.7, the Secretary will set a period of time for the claimant to remedy the defect. Usually the period of time is 7 days. And if the claimant is able to remedy the defect, then the arbitration is deemed to have commenced on the day when the initial version was received by the Secretariat. Well, if the claimant fails to comply with HKIAC directions, then the arbitration shall be deemed to not have been validly commenced, but without prejudice to the claimant's ability to file another notice of arbitration on a later day.
I should note that this is actually a unique feature of the HKIAC rules, whereby there is an opportunity or there is an express provision 4.7 that does allow for parties to have an opportunity to remedy their incomplete notice of arbitration. Not all rules do have that kind of provision, so that's actually usefully addresses what happens if the notice of arbitration does not comply with 4.3.
So, and another document that we usually look at as a Secretariat is the arbitration agreement, to see whether or not the parties actually have an arbitration agreement, and to see what is the basis for us to accept and administer the case. Now, Article 1.1 of the HKIAC rules provides that the rules apply if the arbitration agreement provides for the rules to apply, or arbitration administered by HKIAC, or words to similar effect. Now, what does the words to similar effect mean? The general interpretation is that we will see whether or not there is a identifiable reference to HKIAC administration, and we will look at the contract, the arbitration agreement, governing law, the seat of arbitration, the date of the arbitration agreement, to ascertain an intention of the parties for HKIAC to administer the case. Now, this is an analysis to be conducted on a case-by-case basis. So, and we sadly have to deal with a lot of the pathological clauses on a weekly basis. Here is just a selection of those problematic clauses that I wanted to share with you tonight. So the first clause provides that the case shall be finally settled by HKIAC at the Hong Kong Chamber of Commerce and Industry in accordance with its arbitration rules. Now, I think the problem with that clause is very obvious. The Hong Kong Chamber of Commerce and the Industry actually doesn't exist. So in that case, we have noticed a reference to the HKIAC and in accordance with its arbitration rules. So effectively what we did was to scrap out the reference to the Hong Kong Chamber of Commerce and Industry and treat that as a reference to arbitration administered by HKIAC under its arbitration rules. So what happened in that case was that the claimant actually intended for HKIAC to administer the case under the 2013 HKIAC rules. The respondent did not participate in the arbitration. So we proceeded to administer the case under the HKIAC rules. And if there's any questions or objection to HKIAC's competence to administer the case or the applicability of the 2013 HKIAC rules, we will leave that question to be decided finally by the tribunal. The second clause provides that arbitration shall be referred to the HKIAC for arbitration in Hong Kong in accordance with its arbitration rules. Now, can anybody tell me what is the issue with this clause? Now, the issue with this clause is that is the reference to its arbitration rules. Now, if you look at our website, HKIAC now has 7 sets of arbitration rules listed on its website. The main rules are the 2013 HKIAC Administered Arbitration Rules, but we also have a set of procedures for HKIAC to administer unsecured arbitration. We have HKIAC Domestic Arbitration Rules. We have small claims rules, security transactions rules, etc., etc. So arguably, this reference to HKIAC arbitration rules can include any of those rules I mentioned listed on our website. So what happened in this case was that the claimant actually construed that reference to the HKIAC domestic arbitration rules. Their argument was that this reference was broad enough to cover any set of HKIAC arbitration rules, and the claimant wished to commence the arbitration under domestic arbitration rules because they felt that ad hoc arbitration is generally more cost-effective than administered arbitration. So they made an informed choice to choose the HKIAC domestic arbitration rules, and the respondent objected to that. Respondent considered that the reference referred to the 2013 HKIAC Administered Arbitration Rules. Now, our thinking was that because this reference was broad enough to cover any arbitration rules issued by the HKIAC, and we would generally leave it to the choice of the claimant, because they are the party that commenced the arbitration. The risk of improperly commencing the arbitration lies with the claimant. In this case, we decided to proceed under the HKIAC domestic arbitration rules. The next clause is interesting, and I have received a lot of queries about this kind of clause. And this provides that arbitration administered by HKIAC under the ICC rules. Now, our general policy is this. HKIAC does not administer arbitration under any other institutional rules. We administer arbitration proceedings under our own administered arbitration rules or the UNCITRAL rules. Now, if we are faced with this kind of arbitration clause, what we will usually do is to invite the parties to subsequently agree to change the rules to either the HKIAC administered arbitration rules or the UNCITRAL rules. And if the parties fail to do so, then we will not be in a position to take the case. Now, I know other institutions might take a different approach, and there have been cases which reflect different approaches taken by other institutions. Those approaches, I think it's safe to say that it's not free of criticism, and have been met with risk of non-enforcement in some of the jurisdictions. So HKIAC has taken a more conservative approach.
I think certainly when we were making this call on several occasions while I was Secretary General, one of the considerations was whether the claimant was left without remedy. And certainly because the courts are available in arbitration, certainly the claimant could still go to the court and have the arbitration clause interpreted if they so desired. Or the other institution could deal with it as well. But HKIAC stood firm on its position in taking the more conservative approach.
We just had a very recent case with a similar clause, and the claimant initially commenced the arbitration before the HKIAC, and we invited parties to change the rules. They couldn't. I understand that now the claimant has commenced an arbitration before the ICC Hong Kong office, and the ICC Hong Kong office took it. Now, the final clause I wanted to comment on provides for arbitration in Hong Kong in accordance with the arbitration rules of the Hong Kong International Arbitration Center, brackets SIC rules. The sole arbitrator shall be appointed by the SIC. This is a mixed match clause. It has references to multiple arbitral institutions, and they both exist. So in that case, the claimant commenced the arbitration under the HKIAC Administered Arbitration Rules, requesting HKIAC to administer the case. And they said that the reference to SIC is a typo. The intention of the parties was to agree to HKIAC arbitration, and the respondent disagreed with that. They believe that SIC had jurisdiction over this dispute. But one interesting argument and piece of evidence submitted by the claimant was that before they commenced this arbitration, there were court proceedings in China about this dispute. And in that court proceedings, the respondent actually made submissions that this was a typo. It was the party's intention to refer the dispute to HKIAC arbitration, and now they have changed position after the claimant commenced the arbitration before the HKIAC. So they gave us the evidence, they gave us the respondent submissions, and we looked at it, and we felt that there was a sufficient basis for HKIAC to take the case. But we can't ignore the clear reference to the SIC, especially the last sentence where the sole arbitrator shall be appointed by SIC. So in that case, I gave a call to the registrar of SIC, and I briefed him on this matter, and invited SIC to appoint a sole arbitrator for the parties. And SIC sensibly agreed to that proposal, and eventually SIC appointed a sole arbitrator for this case. And once the tribunal was constituted, the respondent continued to protest, to object to the applicability of the 2013 HKIAC rules and the jurisdiction of the tribunal. And essentially, eventually the tribunal decided that the HKIAC rules should apply. And one factor he took into account was that the seat of the arbitration was Hong Kong. And he felt that that was a strong indication that the parties intended for the HKIAC rules to apply. And he also looked at the court documents submitted by the respondent and their position that the HKIAC arbitration was intended by both parties.
I think that's actually a really good example of how the fact that actually institutions do work together on these types of issues. I know certainly when I was at HKIAC, I gave calls to LCIA and SCC when we experienced or were faced with hybrid clauses and try to find a workaround, or at least try to have a conversation with the other institution as to finding a way to kind of really meet the intent of the parties. And so this is something that I think institutions do try to facilitate the parties' intentions and wishes. And this is probably one of the first times that HKIAC, called SIAC to address one of these hybrid or pathological clauses.
Yeah, we also had other cases where the arbitration clause provided for arbitration administered by the ICC, but the presiding arbitrator shall be appointed by HKIAC. So the ICC Hong Kong office came to HKIAC, gave us a call to say that, this is what the arbitration clause provided for. Could HKIAC appoint a presiding arbitrator for the parties? And we did. Now, how do you serve documents in HKIAC arbitration? When it comes to the submission of the notice arbitration, unlike some institutions, HKIAC does not serve notice arbitration or answer to the notice arbitration on parties. So we require the claimant to serve its own notice arbitration on the respondent, and we require the respondent to serve the answer to notice arbitration on the claimant. But we do supervise the delivery process. So we request the claimant, for example, to provide documentary verification to let us know what means did they use to serve the notice arbitration, whether or not those means were recognized under the HKIAC rules. Now, the HKIAC recognized a wide range of methods for delivering documents. You can deliver documents by email, by fax, by courier, by hand, by register post, and any transmission, any method that provides a record of transmission. And we also will usually ask the claimant to provide documentary verification to demonstrate that the contact details provided by the claimant for the respondent actually belong to the respondent. So it's not uncommon that a notice arbitration will usually include contact details of the respondent. And especially when the respondent is a Chinese company, and then often the email address we get is something qq.com or not a email address apparently associated with any company. So in those situations, we do ask the claimant to provide some documentary proof, at least to give us some record that we can use this email address to effectively contact the respondent. Now, the documentary proof usually provided by the claimant for that purpose takes various forms. Sometimes it's a screenshot of the company's website that includes that email address, or sometimes it's a regulatory filing that includes that email address, or sometimes it's email correspondence, email history exchanged between the parties where the respondent used that email address to communicate with the claimant. So as long as we have a record that allows us to proceed to use that email address to contact the respondent, we will proceed. Chiann.
So I'm dealing with the costs of arbitration. Certainly at the institution, the primary costs that institutions can control are the registration fee, the administrative fee, and the tribunal's fees. And obviously, this is just but a fraction of the total cost, and the majority of the cost being the legal fees. Now, HKIAC does have provisions to deal with that, or at least find a way to limit recovery of those fees as well. But just to kind of go through the types of fees that HKIAC does have control over. First, beginning with the registration fees. The registration fees at HKIAC are 8,000 Hong Kong dollars. In the 2008 rules, this registration fee had to be made for each claim and counterclaim. Under the 2013 rules, this is a one-time fee, and so this is a fee that must be paid by the claimant. And if it is not paid by the claimant, then the notice of arbitration is considered incomplete. And so that is an essential element of commencing an arbitration. In relation to the HKIAC administrative fees, certainly HKIAC administrative fees are very similar to other institutional administrative fees in that they are a proportion or a fraction of the total amount in dispute. Total amount in dispute being both the claim and the counterclaim, et cetera. The real question is what happens if the dispute is a non-monetary, the claimant is seeking non-monetary relief. In this case, HKIAC will give the parties an opportunity to comment as to the approximate value and give consideration as to the complexity of the dispute, and review the contract, and taking into account various factors associated with the claim, and then approximate a figure that is commensurate with the complexity, the nature of the dispute. And so this is something that I don't know how other institutions kind of address the non-monetary claim or relief sought by claimants, but certainly HKIAC has tried to put some metrics or some context around it to give parties some predictability as to what the administrative fees may be when they are seeking non-monetary relief. Another unique feature of the HKIAC costs or fees are the method in choosing how to pay the arbitrators. The tribunal's fees, most institutions will choose one or the other, one be the hourly rate or the ad valorem fee schedule. HKIAC, since its 2008 rules, established a choice for the parties to allow parties to really take control as to their tribunal fees, allowing the parties to consider the complexity of the dispute, the monetary, how long they might think the dispute might run, and give parties a choice as to whether they want to go by the hour or the amount in dispute, by the hour or by ad valorem. Certainly, in our experience, parties tend to choose hourly rate for the larger disputes. That seems to be the more economical measure of accounting for arbitrators' time, and choosing the ad valorem fee schedule for smaller disputes. I think because the default when parties don't agree is the hourly rate, certainly the majority of cases at HKIAC are handled under the hourly rate system.
There's also a cap on hourly rate, which is 6,500 Hong Kong dollars.
And there's also an hourly rate, which I don't know will be revisited in the new sort of...
No.
Right. Just putting it out.
That's a reasonable cap, unless anybody has any thoughts on that.
Right. In terms of the tribunal's power to determine and allocate costs, HKIAC actually has a specific provision, 33.1, that sets out the heads of costs. And this really sets out and defines the types of, and it allows parties to anticipate the types of costs that will be decided upon, or whether they will be able to argue for certain types of costs. The rules also allow for identify certain standards and certain expectations as to the reasonable basis for these costs. And unless the tribunal decides otherwise, these heads of costs are the heads of costs to be considered. There is also a provision to limit the recoverable fees, 33.3, which allows for parties to consider different, allows for the arbitrator to look at the legal costs and allow for some limitation of those costs. Another unique feature of the cost is that for consolidation provisions or for arbitrations that are consolidated, the tribunal will have the power to look back at the unconsolidated arbitrations and take into account their costs as well.
Yeah, and in terms of allocation of cost, even though the HKIAC rules do not provide for a default position in terms of how the tribunal should allocate costs, but in 2015 we compiled a report for the ICC task force on allocation of costs, which indicates that 91% of the awards issued under the HKIAC rules actually follow the cost for the event approach.
Right. It should also be mentioned that even if parties do choose the percentage of costs, HKIAC will ask the arbitrator for their invoices to get a gauge as to the approximate amount of time and value of their fees. This slide basically shows an average cost and duration. I know this study was done late last year. All institutions are trying to get some better metrics on the amount of time spent, the average amount of time spent, and the average cost of arbitrations. And certainly HKIAC has fared well when you look at the comparisons. And our guide also gives some explanation as to the comparison between the costs of arbitration at HKIAC as compared with other institutions.
So in terms of appointment of arbitrators, the starting point is that under the HKIAC rules, parties are free to choose any appointment procedure. They can specify any procedure for the appointment of arbitrators in their contract. But if there's no such agreement, then the default procedure under the HKIAC rules applies. If the parties have agreed to a sole arbitrator, then usually the HKIAC will give the parties 30 days to jointly designate a sole arbitrator. If the parties fail to agree, then HKIAC will appoint. If the parties have agreed to a three-member tribunal, then we require the claimant to designate an arbitrator in the notice of arbitration, and we require the respondent to designate another arbitrator in the answer to the notice of arbitration. And the two co-arbitrators will designate the third arbitrator, which will act the presiding arbitrator. And if there is any default during this process, then HKIAC will step in to appoint. And Schedule 4 of the HKIAC rules also provides that HKIAC shall appoint an emergency arbitrator. There is a time limit for HKIAC to appoint an emergency arbitrator, which is 2 days. But on average, we have managed to appoint an emergency arbitrator within 5 hours. So the reason for that is because usually the requesting party will give us a phone call, give us a heads up to tell us that there is an emergency arbitrator application coming, and to give us preliminary information about the case, the nationality of the parties, amount of dispute, type of dispute, governing laws, seat of arbitration, language of the arbitration. So basically all the information that we need to select candidates. So the selection process actually already started before the application came to the HKIAC. So that is why we, on average, are able to appoint an emergency arbitrator so quickly. Now, what is the internal procedure for HKIAC to appoint? In most cases, arbitrators are actually appointed by parties or co-arbitrators. HKIAC actually appoints arbitrators in a small percentage of those cases. But if we were asked to appoint an arbitrator, the secretariat will first look at the case file, and they will discuss internally involving myself and the Secretary General to prepare a list of candidates for the appointment committee to consider. So the list usually includes 3 names, and we will try to include a female candidate if we can. And we will prepare the AC agenda. The AC agenda will first have a case profile that includes the parties' names, their counsel's names, nationality of the parties, the amount of dispute, governing law, seat of arbitration, the amount of dispute. It's a very neat, tidy, nice table that includes all this basic information. And then it's the background to the dispute, and which includes a summary of the matter, and including a summary of the dispute, the procedure history, and the current status of the case. And then it comes with the Secretariat's recommendation. And then we will tell the AC the factors the Secretariat has taken into account, followed by a list of candidates with a ranking. And then we will also explain to the Appointments Committee the rationale behind the ranking. So that's the AC agenda, and we'll send it to the AC by email, and the AC will comment on the agenda. They may approve, they may disapprove, or they may approve part of it, part of the candidate, the list, and then they may want to substitute some of the candidates for others. So it's the AC that has the final decision on which candidates they wish to appoint. So once they finalize the candidates, we will approach all candidates. And we will ask the candidates to complete certain paperwork. For example, we will ask the candidate to run a conflict check, to sign a declaration form, and provide us with his or her latest CV and his or her proposed hourly rate. And then we will propose a candidate to the parties based on the approved ranking. So we will first put forward the first candidate to the parties. And what is unique about HKIAC's practice in that regard is that we will usually set 7 days for the parties to comment on the proposed candidate. So we'll put a name to the parties to tell the parties that this is the name that we have in mind. We are minded to appoint. This is not a final appointment, and we invite parties to comment on this candidate. So it's a very nice grace period to get any input from the parties before we make the final appointment. In most of the cases, the parties don't have any comments. They usually just don't comment, or they say that we agree. But there are some cases where the parties, they prefer, they have comments on that, they prefer other candidates. Then we will take that into account to decide whether or not to proceed with this candidate. And bearing in mind that we also have 2 other candidates on the list. So if the first candidate is not appropriate for this appointment, then we'll just proceed to the second candidate. Now, so there are a few time limits I have mentioned during this process. On average, the appointment process for HKIAC to appoint an arbitrator takes about 2 weeks.
It should be mentioned that one of the reasons why we set up the agenda the way we did was so that we would put 3 names forward at during any one agenda was intended to allow for a more efficient process. So there would be one decision made by the Appointments Committee rather than, if the first person wasn't available, then having to go back to the Appointments Committee. So that was part of the intention for having 3 names. The other thing that should be mentioned is that this process that Joe has described is expressly tailored for the administered arbitration rules. Now, if HKIAC is faced with an ad hoc arbitration appointment, this is obviously governed by Cap 609C, the subsidiary legislation, whereby HKIAC has to follow the appointment of arbitrator rules, which includes this process, but also requires the HKIAC to consult, or at least consults the Arbitrator Appointments Board, which comprises 10 or so, less than 10 to 15 stakeholders in Hong Kong. So, for example, the Hong Kong Institute of Arbitrators, the Chartered Institute of Arbitrators, and various other interested bodies and stakeholders in Hong Kong do have an opportunity to comment on HKIAC's appointments for ad hoc arbitrations where HKIAC is appointing an arbitrator.
Now, things get a little bit more complicated if we have multiple parties in the case, where, for example, you have one claimant and a group of respondents, or a group of claimants and one respondent, or 2 groups of parties. If the parties have previously agreed to refer the dispute to one arbitrator, it's easier. Then we just follow the usual procedure and set a 30-day time limit for 2 sides to jointly agree on a sole arbitrator. If they can't agree, we appoint. But if they agree to a 3-member tribunal, then sometimes the group of parties is not able to jointly designate an arbitrator. They may all participate in the arbitration, but their interests may not be aligned. Maybe respondent 1, 2, 3 want arbitrator A, and the respondent 456, well, respondent B. But they have to jointly designate one arbitrator. So how do you resolve that situation? Now, Article 8.2c allows HKIAC to appoint all three members of the tribunal if there is any event, in the event of any failure to appoint an arbitrator by any party, or the parties are not able to agree in writing to represent two sides, which might be the case where you consolidate multiple arbitrations into one set of proceedings, where it's sometimes not easy to identify who is the claimant and who is the respondent. And there may be three sides in the arbitration, and they may not be able to follow the usual procedure. So in order to treat all parties equally during the appointment process, we have the discretion to appoint all three arbitrators with or without regard any designation of the parties. And any designations made by a party or co-arbitrator under the HKIAC rules are subject to HKIAC's confirmation. We take a generally low threshold in deciding whether or not to confirm an arbitrator, recognizing the importance of party autonomy. So in most of our cases, we confirm party designation or co-arbitrators designations. But to my knowledge, there have been, I think, 5 cases where in the history of HKIAC, where the institution refused to confirm. Now, the most recent instance was a case where the claimant designated an arbitrator that had advised the creditor of the parent company of the respondent. And the arbitrator didn't make a full disclosure in the first instance, and he waited until the respondent asked multiple questions about his connection with the creditor and of the parent company of the respondent. And at that point, the arbitrator made a further disclosures. And in the same case, the respondent designated an arbitrator who had received designations from the same respondent in 6 other similar arbitrations. Again, the arbitrator initially refused to make any disclosure about it because we administer all those cases, so we knew that the arbitrator was designated by the same party within the last 18 months in 6 other arbitrations. So we actually prompted the arbitrator to make the disclosure. Now, both designations attracted objections from the other side, and they, the grounds is similar. This gives rise to justifiable doubts as to the arbitrator's impartiality and independence, and they refer to various scenarios under the IBA guidelines and the various case law in Hong Kong. And both parties also indicated that if the arbitrators were confirmed by HKIAC, they intended to challenge the other side's arbitrator. So because of the indication of a challenge against the arbitrator, we essentially apply a similar test for challenging an arbitrator in that situation. Now, the test that we looked at was the test decided by the Hong Kong court in 2008 in the case of John Science versus ZTE. So the test essentially is that whether an objective, fair-minded, and informed observer, having considered relevant facts, would conclude that there was a real possibility that the tribunal was biased. So in that situation, we refused to confirm the 2 arbitrators. I think having regard to the relevant situations, and we concluded that there was a real possibility of bias, and also the case was at a relatively early stage, and the fact that we refused to confirm both parties' designations did not amount to a deprival of their right to designate another arbitrator. So we eventually invited the parties to designate other arbitrators in that case.
I know we're running out of time, so maybe want to move quickly forward. I will deal with I will expeditiously deal with the expedited procedure. Suffice it to say, since 2014, or really the rules were launched in 2013, and since 2014, HKIAC has had 33 different expedited procedure applications, with 2/3 of them being accepted. Most of them, when they are not accepted, are due to the fact that the applications do not satisfy the grounds, which include a certain monetary figure, or if with parties' agreement, or in cases of exceptional urgency. Clearly, as with most institutions, the amount in dispute is oftentimes the basis for which expedited procedures are triggered. One interesting aspect of expedited procedures is really the number of arbitrators, and this was highlighted in the recent refusal to enforce a CIAC arbitration award in China, and that case being Noble Resources versus Good Credit. And certainly the approach of the different institutions is quite different. HKIAC takes the approach whereby parties who have expressly chosen 3 arbitrators in their arbitration agreement do not, HKIAC will invite the parties to choose one if the expedited procedure application is granted, but unless parties agree, the number of arbitrators shall be 3, full stop. CIAC's approach, as you now know, for those who have seen the Noble Resources versus Good Credit case, is whereby parties, where the expedited procedures application is granted, it shall be a sole arbitrator unless the president chooses or selects otherwise. In that particular instance, the SIAC there was an arbitration agreement stipulating for 3 arbitrators, but nonetheless, CIAC appointed 1 arbitrator, and this led to the non-enforcement of that arbitration award in China. ICC has taken a similar approach in that ICC stipulates that for arbitration agreements after 1st of March 2007, parties will have been deemed to have chosen a sole arbitrator, but parties can also opt out of the expedited procedures. And so really with all of these provisions, in fact, but the difference in approach between these institutions really highlights the fact that you really need to advise your client as to various elements of the arbitration rules before entering into the rules. And expedited procedures is a different, you are incorporating by reference a set of rules, and so those rules the provisions do apply. So this is one instance that makes it all the more important to advise your clients on that.
Okay. So in the interest of time, I won't go through multi-party, multi-contract provisions in detail, but I just wanted to give a general overview of these provisions. So HKIAC was one of the first major arbitral institutions to introduce a complete set of provisions to deal with multi-party, multi-contract provisions. So these include a joinder of additional parties, consolidation of multiple arbitrations, and the commencement of a single arbitration under multiple contracts. So joinder basically allows any party or additional party to join that additional party into an ongoing arbitration under the HKIAC rules, provided that the additional party on a prima facie basis is bound by the arbitration agreement giving rise to the arbitration. The tribunal has the power to decide on an application for joinder, but if an application is made before the tribunal is constituted, then HKIAC will decide on the application. Consolidation of multiple arbitrations allows HKIAC, upon the request of a party and after consulting with the parties and all confirmed arbitrators, to consolidate multiple HKIAC arbitrations into one arbitration. Now, there are 3 scenarios. The first scenario is that all parties agree. And the second scenario is multiple claims are made under one arbitration agreement. The third scenario is that if multiple claims are made under multiple arbitration agreements, but if there are a common question of law or fact, the claims are made in relation to the same transaction or series of related transactions, and the arbitration agreements are incompatible, then HKIAC has the discretion to decide whether or not to consolidate. So even if those criteria are satisfied, the HKIAC still has the discretion to decide whether or not to consolidate. And we will take into account a wide range of factors in deciding whether or not to consolidate. For example, the stages of each of the arbitrations, confidentiality considerations, the prejudice suffered by any of the parties in the event of consolidation, and whether or not the consolidation decision actually increases efficiency and saves costs for the parties. So we'll take into account those factors and make the decision. The final mechanism was to allow the claimant to effectively consolidate all arbitrations into one at the beginning of the arbitration. So this allows the claimant to commence one single arbitration under multiple contracts. The test is very similar to the test for consolidation, but one additional criteria is that the parties to each arbitration agreement have to be the same. So I have some stats in relation to the multi-party, multi-contract provisions. Since we introduced these provisions in 2013, we have received 8 applications for joinder, and 4 were granted and 4 were rejected. And we have received 14 consolidation requests. 8 were granted, 4 were rejected, 1 is still pending. Finally, I wanted to quickly go through what is happening right now at HKIAC, a very exciting development. We launched a public consultation process proposing changes to the 2013 HKIAC rules on 29th of August. And I have listed the key proposed changes on this slide. They are all available on the website, but just very quickly sort of talk through these changes. First of all, we were thinking about establishing a dedicated, confidential, secure online document repository to store and manage all written communications submitted in an arbitration, and to allow any parties to upload the document onto the system, and the upload of the document would be recognized as an alternative means of service. And the date of receipt of that written communication will be determined by reference to local time at a place of receiving a notice of that upload. So once you have uploaded the document to the system will automatically notify all parties and the tribunal and HKIAC that a document has been uploaded onto the system. And then you will have a password and login details to log into that system to check the document. The second proposed amendment is to expressly recognize alternative dispute resolution during the HKIAC arbitration. So we expressly allow the parties to initiate mediation, for example, after an arbitration is commenced, and any party can request the HKIAC or the tribunal to resume the arbitration. The tribunal and emergency arbitrator may not participate in the other dispute resolution process if he or she may be privy to any ex parte communication with any of the parties, unless the parties expressly agree otherwise. So essentially, this is an R-MED-R process, which we have seen increasing demand in certain markets, such as mainland China, Germany, and Japan. The third proposed amendment is a very interesting one. So we propose to have a default procedure for the conduct of arbitration proceedings in multiple languages, which we often deal with. What that essentially is to achieve is that if the tribunal, all tribunal members are fluent in all languages of the arbitration, then we allow the parties and the tribunal to communicate with each other in any of those languages. So we don't require parties to submit documents in all those languages. The party can just pick one of those languages to file documents, to make submissions in a hearing, or to to comment to participate in a conference call. So this will significantly save costs and increase efficiency for multilingual arbitrations. The next one is to introduce 2 new grounds for joinder. One is to allow the joinder of the fictional party that is not bound by the arbitration agreement giving rise to the arbitration, but all parties agree to the joinder. The second ground is to allow the joinder of additional party that is bound by a different arbitration agreement, but the same question of law of fact arises, and the arbitration agreements are compatible. The next one is to expand the provisions for commencing a single arbitration on a multiple contract. Now, I previously mentioned that under that provision, one additional criteria is to require that the parties to each arbitration agreement to be the same. And we are proposing to remove that criteria under the new rules. Concurrent proceedings. The proposal is to allow the same tribunal or possibly different tribunals to conduct multiple proceedings on a concurrent basis. It can be one after another, or suspend one of the arbitrations until the outcome, until the tribunal determines the dispute of another arbitration. This is intended to cover the situation where the claimant, for example, commence multiple arbitrations in relation to multiple transactions, multiple independent and standalone transactions without any connections with each other, and in those situations, in which case the claimant fails to convince the HKIAC to consolidate those arbitration proceedings. But this would allow the claimant to invoke this provision to request the tribunal to conduct those multiple separate proceedings on a concurrent basis. So this is an alternative means to save costs and increase efficiency in the event that consolidation is not possible. The next one is third-party funding. This is really to follow the recent legislative amendments to the Hong Kong Arbitration Ordinance, and we require a funded party to disclose its third-party funding arrangement to the tribunal, to the HKIAC, to all other parties. We will also amend the confidentiality provision to allow the party to disclose confidential information to the third-party funder. And we are undecided on whether or not to give the tribunal express power to award any cost of third-party funding. The last 2 points are not proposed amendments, but we are very open to suggestions and comments as to whether or not we should include express provision to deal with these 2 matters. And one is to introduce an early determination procedure to allow the tribunal to determine a question of law or fact in a preliminary or summary fashion. So this will be similar to the summary judgment procedure available in the Hong Kong courts. The last one is to consider whether or not to issue a set of combined rules that are applicable to both commercial arbitration and investment treaty arbitration. And what we have in mind right now is to include a new schedule, including provisions that will be applicable to investment treaty arbitration. For example, submissions by third parties, and a waiver of immunity, transparency of the arbitration proceedings. But we now invite everybody's comments on what should be the provisions included in the schedule. So the public consultation process is still ongoing, and the deadline for public submissions is 2nd October. The consultation paper and a clean version of the new rules, the proposed new rules, are available on our website. But if you would like to have a track change copy of the rules reflecting changes to the 2013 rules, please send a request to rules@hkiac.org. We'll be very happy to send you a track change copy.
Great. I know that we've probably overrun a bit, but if you have any questions, maybe we can just take that outside, or how would you like to conduct that? We're happy to take them now, too. Oh, right, of course, sorry. Right.
Jared, our Philippines chapter can also put questions if they want. Anyone from the floor has questions for our 2 speakers or those in Philippines?
Hi, Mary. We are now looking for people who have questions. I actually have a question, but more on just a point of curiosity regarding the early determination procedure that's being envisioned by the HKIAC to be added to its rules. Perhaps it's something that perhaps more details on it can be given so that we can perhaps find something that may be similar to the Philippine jurisdiction. Because as you said, this is something similar to summary judgment under Hong Kong law. Would you happen to have a more detailed explanation of what this procedure is?
We don't have a draft at the moment, and we are very open to any suggestions. And we have looked at the procedure under the new CI rules and also the new SCC rules. We are undecided as to what exactly will be the procedure and even whether or not we should introduce this procedure at all. But I think the general understanding of this kind of procedure is to allow the tribunal to deal with any claims or defenses that have no real prospect of success, and in a summary manner instead of going through the entire process. So what is available in summary judgment procedure in many common law jurisdictions is to achieve a similar effect. For example, if you have a very straightforward loan collection claim, that there is just no real prospect for the respondent to defend that claim. And then judges in some jurisdictions would just deal with that claim to dismiss it or to uphold it in a summary manner instead of going through, for example, document production and calling witnesses or even have a hearing to cross-examine the witnesses. So this is, I think, the general approach to that effect, but different institutions have introduced slightly different procedures as to the meaning of it. We currently don't have a draft about that, and we don't really have a sort of a clear definition of it. So that's why we put that in the question section, and we're inviting submissions and comments on that.
Can I just mention, Jared, and to those who are here today, today I actually received an email from Joe canvassing comments from our institute, from the Chartered Institute itself. So we're going to be circulating it in terms of the paper that Joe has given to us, so that we can collect it and we can provide it by the deadline that has been mentioned in early October. So Jared, if your chapter is also interested, we can circulate what we've received from Joe, and your comments can be collected together and presented by the Chartered Institute East Asia branch. Okay?
Yes. I think that would be a good idea, so that we can also take a look at those comments and perhaps provide our own ideas.
Okay, good. Simon here has a question.
Yeah, so well, just on the early determination procedure, I think others will comment as well, but I think there are clients who are put off from providing for arbitration because of the lack of early determination procedure. So I think it's something which would be of interest. It would attract, I think, more arbitrations here. But my question was a small question, really. Just on the you mentioned it's not often that HKIAC has the opportunity to appoint arbitrators. I was wondering how many have you appointed in, or how many do you normally appoint in a year now?
I don't have an exact figure here, but I think usually it's between 100 probably to 150. That would be the the rough figure that I would anticipate. So we don't just appoint arbitrators in administered cases, but as you know, we also appoint arbitrators in ad hoc cases as the default appointing authority. So I think that's probably sort of an average figure that we see in our appointment cases.
I would also say that, just recalling back at my time at HKIAC, these appointments are oftentimes, I mean, the nature of the disputes, the amount in disputes, really, once you have that dispute at hand, the pool of arbitrators quickly narrows based on the amount in dispute, certain qualifications, certain linguistic requirements. And so actually the type of arbitrators that HKIAC looks at kind of fall into certain categories, and so oftentimes the reality is that, you know, for a certain type of dispute, a certain profile of an arbitrator may actually only be eligible 5 times of the year, something like that. So it is quite diverse in types of the needs of the arbitrators that our HKIAC sees in terms of its cases.
But we're constantly looking to diverse our appointments, and we are more open to appoint new arbitrators. You know, we have been trying to identify those arbitrators in Hong Kong and outside Hong Kong, and we constantly revisit our panel on the list arbitrators. So one factor we do take into account is the number of appointments the arbitrator has received by HKIAC or parties over the last 2 years, for example. And we try, you know, I mean, in appropriate cases, yes, you appoint those. There are certain type of arbitrators that we usually appoint, but I think there are more and more cases where we're open to appoint arbitrators who are less busy, who will be able to devote more time to the case, or probably have more commitment to the case.
The other aspect as well, HKIAC, I don't think at this point publicizes its appointments the way ICC does. Certainly, its counsel has visibility on all the appointments that are made, so there is some general oversight as to the appointments made.
Can I ask, following from your mention on ad hoc arbitration, you mentioned that you're required to consult various interest groups, including the Chartered Institute. Has that happened? Because
I'm not sure.
How does it work?
Yes, so that is actually stated in the subsidiary legislation called the Arbitration Appointment of Arbitrators and Umpire Determination of a Number of Arbitrators Rules, CAP 609C, which requires HKIAC to consult with the Appointment Advisory Board, which includes representatives from the judiciary, the Institute of Surveyors, and I think the Construction Society. I'm not entirely sure whether or not CIArb is on the board, but I think it probably is, but I don't know. So there is a board, and we are required to consult with them about a potential name that we put forward for that appointment. So we will send them a letter proposing a name, and then we'll get comments from them.
And by them, Joe means that actually each institution designates a representative that serves on this appointment advisory board for a period of 3 years, or renewable 3 years, something like that. And so that person, that individual, receives these letters. And so I think there are now like 14 different stakeholders, and HKIAC has to at least consult 3 of those stakeholders.
Every time.
Every time.
Yeah, and the names are all published on the website.
Okay, it's just that it wasn't something I was aware of, or I don't remember our committee ever receiving such a request. So.
Yeah, I think it's to check the website to see whether or not CIArb is on the board. But what I'm sure about is that the judiciary is on it, the Institute of Surveyors, the Construction Society,
Society of Construction Law, HKIArb, I think.
And the Law Society, the Bar Association.
Yeah.
The other thing was you mentioned that now whenever appointments are being considered, you will have 3 names, one of whom will have to be a female as well. Does the HKIAC now publish statistics on their appointments? I know that SIAC has done in terms of like the proportion of the split between for genders. When I did a talk once on unconscious bias, I tried to get statistics from the HKIAC. They had to manually count them because they don't have those figures ready. Do they now do that? We
do. So we actually have been publishing stats about the number of appointment of female arbitrators since 2 years ago. So and we now maintain a rolling list regarding the number of female candidates the Secretary put forward, and the candidates that eventually approved by the Appointments Committee. So now we have those stats ready, and we have a person who is dedicated to updating the stats.
Any other questions from the floor or from the Philippines? If not, I see we're getting towards 10 minutes to 8. Thank you so very much to Joe and to Chiann for spending the time preparing for this talk and delivering it so eloquently and taking questions. Thank you very much. And before you go, we have a little souvenir for each of you. This is our Chartered Institute East Asia branch souvenir. Even the committee members don't have them, but we do give it to our speakers. So maybe ladies first. I'll give
All right,
Chiann
thank you very much.
for a scarf, and Joe for a tie. It's in bright red for those who can't see it, but also they can be purchased from the East Asia branch. So we'll try to put an article in our newsletter so that you can see it.
You might get a discount rate if you buy this together.
Exactly. But can we thank them in the usual way? Just to mention that our next talk is on the 30th of October, and it's on some thoughts on arbitration rules. So we're trying to do a few events on rules, and it will be delivered by Professor Insamo Reyes. So I hope you can attend again. And we would also invite the chapters to actually call in by webinar if they like. So take note, Jared, you'll be invited to join again. Thank you.
Yes, we'll do. Thank you.
Okay, good. Have a good evening. Bye.
Very good. Thank you.
Uh,
And thank you, DTI, as well.